Okay, for today's class, we're going to go over utility patents. So let's turn to the first slide. As you can see from the first slide, there are basically only 3 laws you have to get past to get a patent, but it's not quite that easy, and we'll be spending a good portion of the rest of the class going over why it's not so easy. So the 3 laws here are 35 U.S.C. 101, 35 U.S.C. 102, and 35 U.S.C. 103. 35 stands for the title number, USC United States Code. Patents as well as trademarks and copyrights are handled under federal law. And the section number 101, 102, and 103, these are the sections of the book. So back before we had the internet, you had to go to the library, look for the United States Code, then find book number 35, which was actually a bunch of books, and you'd have to look under each book to see whether you could find the correct section number. But now we've got everything on the internet, so you just have to pull up the internet, type in the name of the law, and find out everything you need to know about it. So let's start with 35 U.S.C. 101. 35 U.S.C. 101 says basically, is your invention patentable subject matter? Now, to be patentable, it has to be new and useful. It's got to be new. You can't go and patent the automobile wheel again. Henry Ford already did that in the early 1900s. And it has to be useful. Now, useful is an extremely broad term. I've seen some of the most useless inventions ever get patented. For example, probably one of the silliest is it's a wheel with boots that rotate around and kick someone in the head. So useful, yeah, right, okay. Useful enough to get a patent, I guess. What they're really aiming for with usefulness is that you can't patent things that don't work. So like perpetual motion machines are unpatentable because they really don't work. Now, if you look at your slide, you can see that it's basically divided up into 3 sections. There's business methods, products, or they call them manufacturers, and then there are substances. And so if you create a new variety of maple syrup by mixing a bunch of different flavors of maple syrup from different parts of New England together, that could be potentially a patentable substance. If you create a device like a new baseball bat that bends a little bit when you hit the ball, okay, that's a product you may be able to patent. Business methods are really an odd bird because business methods were decidedly patentable 20 years ago. But the rest of the world doesn't really like business methods. And so over the years, we've seen a gradual erosion in the patentability of business methods. And I hesitate to put on a video exactly what the test is for a business method patent now, because it seems to change every week or two. Suffice to say that if you really want to find out what the latest test of business method patents is, you can get on the U.S. Patent and Trademark Office website. They have a complete section that's dedicated to business method patents. One interesting statistic is that we've had 2 fairly important decisions on business method patents. One was the Bilski decision, the other was the Alice decision. Now, after Alice, the patentability success ratio percentage for business method patents went from almost 1/3 down to 6% pretty much overnight. Now it's climbed back up, and again the criteria under which a business method may be patentable seems to change every week or two. But at this point, I am not recommending business method patents unless you happen to have the reserves of, say, an Amazon.com or something like that, because it's sort of like playing basketball, except that once you take a shot, the shot may take 1.5 years to travel through the air, and in that time, the USPTO and Federal Circuit, they may take the basketball hoop and move it off to the side. They may make it smaller in diameter. They even raise or lower it. So you're taking a shot, and you really don't know what the basket's going to look like 1.5 years from now or so, whenever your patent application gets examined. Okay, 35 U.S.C. 102. This is the second law you have to get by. 35 U.S.C. 102 says basically, did somebody else beat you to the USPTO in terms of a filing deadline? You can't patent the same invention twice. Otherwise, everyone would be trying to patent the light bulb and the internal combustion engine as soon as their patents were ready to expire. So you can't patent the same thing twice. Now, with 35 U.S.C. 102, you're hoping that the prior art search, which I'm going to talk about next, will flesh out any patents that are in existence at the time you file your application that are exactly like your invention. Now, prior art searches are not perfect. I'm going to be going over that shortly. But a prior art search is a great way to try to find out what else is out there that may be directly on point with your invention. Because if somebody else has a patent on your exact invention, not only will you not get a patent on your invention, but if their patent is still in effect, you may be infringing their patent by making your product. So this is fairly important stuff to figure out at the beginning. 35 U.S.C. 103. This is the last law you have to get by. And this is the law for patent attorneys either make or don't make their money. 35 U.S.C. 103 says that if your invention is a mere obvious improvement over the prior art, you won't get a patent on it. Now, what's an obvious improvement? That's obviously another very loose term. And so there are a bunch of examples and tests for what's an obvious improvement. For example, if it brings unexpected benefits to your product that you wouldn't expect from looking at other patents in the area, or if it is heading in a new direction where your invention suddenly takes the kind of the state of the art, the general impression of where this particular type of product should be going, and you just completely turn 180 degrees away, and suddenly you're inventing in an entirely new stratosphere, then that's good evidence that it's not just an obvious improvement. Commercial success is another, that's a great one for us to argue if we're arguing against a 103 rejection, because we can say, how can my inventor's invention possibly be just an obvious improvement over these if my inventor has sold so many and been so successful? Other things you can do as an inventor to try to help the patent attorney get around a 103 rejection is, frankly, be successful. Get a licensing deal, win some awards and invention shows, be written up in some of the trade magazines as being one of the most influential and important inventors in your area. These are all things that you can do to try to prove that your invention is something more than the proverbial obvious improvement over the prior art. Okay, let's turn to the next slide. This is on prior art searches. A prior art search is a search that looks for any patents, published patent applications, products for sale out there on the internet, papers written about a product that were public domain, that is, the public could see them before your filing date. Now, there are different laws on different types of prior art, but suffice to say, the goal of a prior art search is to find things that may get in between you and your ability to get a patent. Now, prior art from anywhere in the world can be used to shoot down your patent application. So if you're a U.S. inventor and you've never even heard of any of these products even being sold in Mongolia, but a Mongolian inventor has patented your invention 5 years before, the USPTO examiner can use that Mongolian patent to shoot down your patent application. Now, a lot of people complain about this and say, well, that's not fair. Well, actually, it benefits United States inventors more than inventors from other countries, because let's say you take the most obscure little nation in the most obscure region of the world, and an inventor there files a patent application on something. You can bet that the examiner in that obscure nation is going to look at the U.S. Patent and Trademark Office records to see if he or she can find any prior art. But if you submit your application to the U.S. Patent and Trademark Office, it's very doubtful that that examiner is going to look in this little obscure nation for prior art. So this rule actually helps United States inventors. The U.S. Patent and Trademark Office examiners will usually look at the USPTO, European Patent Database, Japanese Patent Database, sometimes China, sometimes South Korea, maybe Australia, maybe Canada. But by and large, there are usually only about 10 patent databases that even the most thorough examiner is going to look at. So the prior art search, again, it looks for public records that show that you may have taken your idea from other people. Now, prior art searches are never, ever, ever perfect. As I said, a patent from Mongolia can be used to shoot down a U.S. invention from getting a patent. And it's very doubtful that a prior art searcher is going to look in Mongolia for prior art. So first of all, even if you hire 2 or 3 of the best patent prior art search firms in the world, they're probably not going to find everything. The second thing is, remember the provisional that we talked about last time. Provisionals are not public record until a utility patent that's filed claiming the priority back to the provisional becomes public record. So you got the provisional for a year. You've got 18 months before utility patents are normally published. So that's 2.5 years of gray period during which nobody knows what's out there. So the prior art search has built into it two pretty significant flaws in that it doesn't cover the entire world, and there's going to be about a 2.5 year gray period during which you're going to have no idea whether something else was filed that could shoot down your invention. The flip side of that is you can file a provisional on your application. Within a year, turn that provisional into a utility, and then you have 2.5 years to develop your invention before anybody else knows about your patent application. So prior art searches are not perfect, but I highly encourage them because they're a great way of finding out what else is out there. I personally don't do them because I think it's something of a conflict of interest for the attorney to be searching for things that may or may not dissuade the client from deciding to give that attorney a bunch of money to file and prepare and file a patent application. But there are a number of good reputable firms. If you're interested, send me an email. I'll send you a few that we work with all the time. Average cost for prior art search, right around $800 for a simple invention, more for a more complex invention. And again, the prior art search usually takes somewhere between a week and 2 or 3 weeks, depending on, again, the complexity of the invention and how much you want the prior art searcher to search. I would avoid using for prior art searches a company that tries to sell you a package deal that includes a prior art search and the utility patent application and the trade show booth and the prototype, because the whole purpose of the prior art search is to try to let you know whether you should proceed, first of all, even making the product, second of all, with a patent application on it. And so these invention promotion companies that sell this package deal, well, why are they already selling you the utility patent application and the prototype before they've done the prior art search? Might want to ask them that. We'll have more on invention promotion companies later on. But again, prior art search, great way to start. And believe me, with the cost of utility patents and the preparation cost and the prosecution cost, it's much better to spend $800 or so when you're starting out and know from the beginning if your idea is fatally flawed. Let's find out at the beginning so you can come up with another idea, rather than spending $8,000 on a utility patent application only to find out a year and a half later after you file the utility patent application that you never should have had it prepared in the first place because there was prior art on your idea that made a utility patent nearly impossible to get on your particular product.